Now we're talking about warrants. The Fourth Amendment deals with the warrant as well, not just the probable cause and the issues of the warrant, but the warrant itself must be particular in what it describes and what and where the search may occur. There are two basic types of warrants. There's an arrest warrant and a search warrant. An arrest warrant obviously can be executed anywhere, and it is simply to place someone under arrest. But it also doubles as a search warrant for the individual named. In other words, if they think the person on the warrant is in a house, they can come in and search the house for the person on the warrant. They can't search for other things, but they can get in the house and look around, and anything that they see once they're in there is fair game. If you're in a house and the police show up for a warrant for someone who is also in that house, and again, there are a couple of scenarios. If you're a parent and your child is there, if you're the owner of the house and that person is there as a guest, if that officer shows you a warrant, cooperate, period. There's no ifs, ands, or buts. Cooperate with that officer, allow him in the house. You have to. You're obligated by law to obey that court order, which is the warrant. But that is not a warrant to search your house. So if they come in and they find the subject of that warrant, or for instance, let's say your son answers the door and steps out and says, "Here I am, officer." Now there's no reason to come into the house and search it for him. They have it. They've successfully executed the warrant. The warrant has been served. End of warrant. If you say my son is not here, and he says, "Well, I'd like to just come in and check," again, cooperate. You should be telling him the truth. He can walk through. Again, he can't start pilfering through drawers, but he can walk through and look and see if your son is there. That's a rapid, quick way to cooperate and get that uncomfortable situation over as quickly as possible. If they find things if they walk into the house to search for a 200-pound man and they see a bag of contraband on a coffee table, now they can search for more contraband, even though their original warrant only let them search for a 200-pound man. So it is fluid. Once they get into a place, what they can legally see where they are legally standing can broaden the search legally. A search warrant describes specific things. It's not an arrest warrant, but it describes what they are looking for and where they may look. So they come into a house and they start looking for a 200-pound man on an arrest warrant. Where can they look? Well, they can't look in shoe boxes, and they can't look in places that a 200-pound man would not fit. They have to look in reasonable places to try to find what they're searching for. The same would apply if they were looking for a package that had been delivered by UPS, and they knew the size of the package. They couldn't look in drawers too small for the package to fit in. They couldn't look under beds that the package wouldn't fit under, but they could look under beds where the package would fit, and in drawers where the package would fit. Then, as they're looking, what happens if they find a locked space? For instance, they find a suitcase that's locked, or they find a door that's locked, or a small curio that's locked. What the owner of that space has said by locking it is, "I have a separate expectation of privacy in this item: curio, safe, suitcase." He can seize that suitcase if he has reason to believe that that suitcase could contain something he's looking for. In other words, if he's looking for the 200-pound man and he finds a locked suitcase, he can't seize that suitcase. Can he ask you to consent to open the suitcase? Absolutely. And again, you can either consent or say, "No, I don't want you looking in my suitcase." It's your right, but you must assert it. When they show up at your door with a warrant, they must read it to you and provide it to you. They have to announce the warrant. And not only do you get that copy, but you get the right to have it read to you. Because if you're extremely surprised at them showing up and searching your house, it might be a mistake. No one's perfect. If you live at 2002 and the warrant's for 2020, you should walk up to the officer as quickly as possible and say, "Officer, there are some criminals apparently down the block at 2020. Why don't you go down there?" So if you can assist them and help them find what they're looking for, do so. If you don't know what they're talking about, simply allow them to look in the places where it could reasonably be, stay out of their way, and make sure they don't abuse their reasonableness standard. Reasonable is not pulling out drawers and dumping them all over your house. Now, can you stop them? I doubt it. If a police officer is going to act poorly, standing there in your house, you practically don't really have the ability to walk up and say, "Stop, officer," but certainly make notes. Don't feel constrained to sit there and take it. But again, you have to cooperate even with a poorly acting police officer. That doesn't mean you're helpless. Make notes, take pictures, make observations. If it's a number of police officers and some are more reasonable than others, approach the reasonable officers and say, "Officer, is that really necessary?" Once the officers leave, there are a couple things that you should do. If you think the search was unreasonable, you should definitely go around and take pictures that demonstrate that. If things were broken, if property was damaged, if drawers were emptied and tossed around for no apparent reason, you should document that so a judge has evidence that he would need to determine whether those police actions were reasonable even with the warrant. If you're in an automobile, the United States Supreme Court has created an exception to the Fourth Amendment. And it's based on the theory that automobiles are much more mobile, and therefore any evidence that might be in them is easier to get away from the police officer and destroy, if there is in fact evidence in the car. And what that means is the United States Supreme Court, by creating this exception, has excused the need to go get a warrant to search an automobile in almost all circumstances. That doesn't excuse the need to have a reasonable suspicion or legitimate reason to stop the automobile. That doesn't excuse them trying to get consent from you. So you may be asked if they can search your car. And if you say no, they still need some other reason other than you saying no to justify that intrusion and that detention. It has to be based on a reasonable suspicion. Back to the Terry standard. But if they have that reasonable suspicion, they can go farther than they could if you were just standing out on the street. If you're asked to consent to a search and you say no, and the officer's response is, "Well, fine, we'll go get a warrant anyway," and you go ahead and say, "Well, all right then, you can search the car," that is not consent. And that is, by definition, a coerced consent that is not valid, and the search would not stand up. Again, if the officer kept his word and went to get the warrant and didn't rely on that consent, he'd be okay. But if he relied on that consent and took a shortcut, it would be an invalid consent and an invalid search. The next aspect is if you're in your home, and that same coercion or submission to authority rule exists. If you're in your home and the officer walks up and says, "I want to search your house," and he doesn't have a warrant, and you say, "No, I don't want you in my house," he cannot coerce you by saying, "Well, that's fine, we'll go get a warrant anyway," and then get you to consent that way. If he does, however, go get a warrant, or if he shows up at your door with a warrant, again, you must be cooperative, respectful, and allow him to execute that warrant.